Hello, I'm Constitutional Attorney Katherine Henry, and today I'm going to talk to you about the 85 most common legal terms used in criminal cases. Now, this is a four-part series where in the first series we actually talked about the most common general legal terms. In the second part of the series, we then talked about the most common terms used in civil cases. This is the third part of the series where we're talking about criminal terms. And in the fourth part of the series, we're talking about the most common legal terms in appeals cases. So we're going to go ahead and get started with those 85 most common terms used in criminal cases right now. The first one we're going to go over is appearance, which is simply the act of coming into court, appearing in front of a judge for a court hearing. Arraignment. In criminal practice, it's bringing the prisoner to court in person to answer for a charge, where they are going to plead guilty or not guilty, be told of their rights, make sure that they have been in fact told of their rights so far. They can request for the appointment of an attorney. It's typically after that point, at least in states like Michigan, where a public defender would be appointed between then and the pretrial conference, etc. Bail is the cash or other security placed on deposit with the court to obtain the release of an arrested or imprisoned person and to guarantee his or her reappearance before the court on a specified day. Bail bond is a financial obligation signed by the accused and those who serve as sureties to guarantee his or her future appearance in court. Bench warrant is an order issued by the court or from the bench for the attachment or arrest of a person. Bind over. This term is not used in all jurisdictions, but it is in places like Michigan, and it means to hold for trial, a finding at a preliminary hearing that sufficient evidence exists to require a trial on the charges made against the defendant. And this procedure happens in Michigan in felonies and high misdemeanors, but not in traditional misdemeanors or in civil infractions cases. Brief. It is a written argument submitted to the court by a counsel or by a person who's not represented by an attorney, setting forth their facts and the law that support their case. Burden of proof, the duty to establish a fact or facts in dispute. So, for example, the plaintiff in a personal injury lawsuit has the burden of proving that an injury occurred and that the defendant caused it. In the criminal context, the burden of proof is beyond a reasonable doubt, and it is the prosecutor who bears that burden of proof, and they must prove not only that he did it, right, that the defendant did the crime that he's alleged to have done, but the prosecutor must prove each element of the offense of the crime beyond a reasonable doubt. Burglary, the breaking into and entering of a building to commit a serious crime inside of it, such as robbery. Caption, that's the heading of a document prepared for consideration as part of a court proceeding, showing the names of the parties, the name of the court file number. It's the stuff at the beginning of the document that just says, hey, this is what case this belongs to. Challenge for cause. It's an objection to the qualifications of a particular juror for a reason that is stated on the record, usually on the grounds of personal acquaintance with one of the parties or the existence of some other bias that may affect the verdict. Challenge to the array, however, is to question the qualifications of an entire panel that is summoned for jury duty, usually because of alleged partiality or some deficiency in the manner by which the panel was selected or summoned. Circuit court. It's the highest trial court of original jurisdiction in some cases, in some jurisdictions, like in Michigan, for example. So in Michigan, if you are charged with a misdemeanor or a civil infraction, that is heard in the district court. The whole process, start to finish, happens in the district court. If you are charged with a felony, however, the case starts in district court, but then once you are bound over, you are moved up to the circuit court, and then all other proceedings, all motion hearings, the actual trial itself, the sentencing, all of that happens in the circuit court, which is the highest trial level court in the state of Michigan. Circumstantial evidence. It's indirect or inferred evidence, as distinguished from direct or eyewitness evidence. For example, just before retiring for the night, a man looks outside and sees that the ground is bare. But when he wakes up the next morning, he sees that the ground is covered in snow. He concludes that it snowed during the night. The evidence on which he based this conclusion is indirect or circumstantial. Why? Because he didn't actually see it snow. It's evidences of the circumstances that point him to that conclusion. Commutation. The reduction of a sentence as from death to life imprisonment. When your sentence is commuted, we've seen that with presidents when they first come into the presidency, and it's typically when they first enter the office and when they're just about to leave the office after somebody else has been elected. It happens with governors, but typically speaking, when a sentence is commuted, that means that it is shortened or even set aside completely. Concurrent sentence is a sentence for a crime that runs at the same time as that for another crime, rather than successively. So those of you who might know that myself and my family, we were victims of a crime in our neighborhood. A neighbor had some apparently never before diagnosed mental health issues, which led her to coming to our home with a sledgehammer and physically threatening my son, and then destroying and taking parts of our property. And it caused a whole big problem with us. She only lives a few doors down. And so she ended up being arrested and charged, and just earlier this year was finally sentenced for that. This is like a year and a half ago that this happened. So she was finally sentenced in February of this year. Unfortunately, she received concurrent sentences. So her sentences are just stacked on the same time frame. So even though she received 2 years for one, 2 years for another, et cetera, because there were multiple charges, they're not added one to the other. They're not served, front to end with the others. They are essentially served all at the same time. Contempt of court. An act that embarrasses, hinders, or obstructs a court in the administration of justice or lessens its authority or, dare I say, dignity. I'm not a fan of this concept, as you could tell, but contempts, generally there's two kinds. There's direct contempt and indirect. Direct is where it happens in front of the court, in front of the judge, typically on the record in court. Indirect is where it's committed outside of the presence of the court. So, for example, a failure or refusal to obey a lawful court order. Corpus delicti. That's the object or thing upon which a crime has been committed. So, for example, the body of a murdered person or the charred shell of a burnt house.